LLC versus Roswell. And after that, we'll hear from number 14, West Bank Trust versus QT.
May it please the court, Charles Walshine for defendant appellant, Phyllis Ferraro. There are really three issues upon appeal, and respectfully submit that I don't think the court really has to get past the first one, which is the law of the case. Back in, I think it was 2018, there was the initial motion for summary judgment was made, and then there was some discovery filed by defendant's predecessor counsel to me, I think Ron Weiss, sort of discovery demands. Those demands were never answered, and the plaintiff sought leave to make a second motion, and Judge Molia, in her order, says, I think in 480, stated that you can make a second motion for summary judgment when discovery is complete. Judge Molia then we had COVID, and in 2021 she retired, and as did her law secretary Gary Brunges, and the case was reassigned to Justice Heckman. Plaintiff makes another motion.
What was the missing discovery?
There were questions about the note. That was the possession of the note at the commencement of the action. There was questions about the mailings of how the 1304 notices were mailed. Basically, documents that would have been in the plaintiff's possession, and then of course there would have been depositions. We would have been ready,
But weren't those documents filed with the court in different motions in the first motion?
Well, there were questions about the documents themselves. Just the fact that they were in there doesn't mean that discoveries about not only getting them, being able to have real discovery, and actually being able to cross-examine someone before trial. And Ron Weiss's office was very was diligent in pursuing that type of information that were raised in the defendant's affirmative defenses. So the fact that there was another summary judgment motion made, with or without the opportunity for the defendant to cross-examine or to actually have these documents in hand, which was later, this is basically a successive motion for summary judgment, and also violated the law of the case, because the court clearly said you may not.
Will denial of a summary judgment motion constitute law of the case?
That's not the law of the case part. That's the successive motion for summary judgment part. The law of the case is you can't make a second motion until you turn over these documents, and it doesn't mean that turn over the documents in your second motion turn over the documents
within the denial of the summary judgment motion. So you're parsing that out. Is that something that can get parsed out?
Yeah, I think one is just a denial that no, you are not getting summary judgment. The second is you may not make the second part of that is you may not make a second motion until the discovery is complete.
Okay. Do you have another argument that you'd like to make?
There's the evidentiary deficiencies judgment, and there's also, I believe, issues of fact created by the plaintiff's own admissions concerning who and when to transferred the documents. There's a 2019 date there's an admission by the plaintiff. I think it was Mr. Lazar who testified that they didn't receive the documents until 2019, and this case started in 2015. And that would have also been a point of discovery and cross-examination to which the defendant was not permitted. And then we get finally to the judgment for foreclosure and sale, which also contains, I think, the most glaring deficiency is that the facially deficient, the plaintiff's records, most of them, you say summary at the top, which would mean that this is a summary and it's prepared for litigation and is not admissible as a business record. If the court has no further questions, I believe everything is, it's a detailed appeal, and these would be, I believe that there's a robust record for the court to make a decision.
We have the record, we have it. Thank you very much.
Thank you.
Morning, Your Honors. May it please the court. My name is Monica Christie. I'm of Hill Wallet. Just got subbed in. Apologize for any stress or confusion here.
Let me start working on you. You moved for summary judgment the second time before responding to the appellant's outstanding discovery demands. Why was it appropriate to proceed without producing that discovery?
Well, we believe that there's no evidentiary basis to suggest that discovery would lead to different outcome. I mean, the appellant and the borrower themselves came to Druckmann's office and saw the original note. And the reason why there was a difference between the 2019 date and that confusion is because the client asked the custodian to get the original note, send it to Druckmann's office so that they could review it, and then Druckmann sent it back. But my thing is, I respectfully request that the court affirm the lower court's entered judgments as they were right and just, and I respectfully request that you vacate your stay of the sale. Summary judgment was rightly granted for 3 reasons. Summary judgment was not premature based on the discovery. As I said, there's no evidentiary basis to suggest that discovery would have led to different outcome. There's no note possession issue. Once again, I had mentioned that on June 6, 2019, the appellant and her counsel physically appeared at Druckmann Law Firm to inspect the original note. And it's the same note that was attached to the summons and complaint. Also, there's no 1304 issue because all 3 client affidavits clearly laid the foundation to submit the copies of the letters and the proof of mailing, and the court found no issues with the additional protections listed and afforded the identified parties in the statutory language.
Counsel, your adversary seems to suggest that there's some conflict between the Lazar affidavit and the Reeves affidavit.
I'm sorry, I didn't hear you.
Your adversary seems to suggest that there's some conflicting statements in the Lazar affidavit and the Reeves affidavit.
With respect to
Personal knowledge, the documents not being attached.
that's untrue, because I did look at them. They all 3 had the 1304 letters and the proof of the mailing. What there was that little bit of confusion about the 2019, and what happened is they attached the transfer from the custodians. The fact that they're using a custodian to hold the note doesn't make any difference as to whether or not they are the holders of the note.
Thank you. Anything further?
Appellant appellant for the final judgment says that the affidavits are their affidavits, which they are not. He makes a deal about that there's run dates of May 2nd, 2023. You can use summaries in litigation. They have to be made at the time of the entries have to be made at the time that they were made. You can collect everything together, make it as a submission. Appellant offered no counter evidence, no support of their request, no receipts for taxes paid, insurance paid, payments not made properly, payments not accounted for. He provided no counter no counter evidence.
Thank you.
Thank you.
Take care.